Yesterday's ruling acquitting Deputy President William Ruto and Joshua Sang may have ended a 6-year-long anxiety, but after studying the 253-page ruling, their defense counsels are not entirely happy. They are aggrieved because the chamber had not expressly acquitted their clients, despite finding by majority that the prosecution had not presented sufficient evidence. Presiding Judge Chile Oboy Osuji noted in the ruling that witness interference and political meddling had led to a mistrial.
As we all know, Mr. Sang enjoys no political office, no public service of leadership, not even religious leadership. And so to victimize him on account of, for instance, political interference is extremely unfair to him.
What he viewed as part of what he described, Presiding Judge Oboy Osuji, as intolerable political meddling was the sovereign right of the Republic of Kenya to address the Security Council, which is the primary organ in the international community under the UN Charter for maintaining international peace and security.
But as they ponder their next move, the chamber's decision by majority that the prosecution had relied on deceitful witnesses to build a case around a non-existent common plan and a network that later disintegrated vindicated them.
This isn't keeping up with the Kardashians.
The former prosecutor of the court, Luis Moreno Ocampo, who initiated the cases, grabbed headlines for his sentiments that the Kenya cases would serve as an example to the world.
The prosecution, and particularly Luis Moreno Ocampo, has a case to answer as to why on earth was it, on the eve of his departure from the office of the prosecutor, did he rush to name the big sexy names of Kenya, Uhuru Kenyatta, William Ruto, and all the others, Ambassador Mathara, in a rush that wasn't based upon proper, diligent investigations.
In the interest of international criminal justice, the defense says the Assembly of States Parties should in fact consider a wider probe covering the entire institution of the ICC, which they argue sanctioned a trial based on sloppy investigations and weak evidence.
You can't say the emperor is properly attired in a crown and lovely silk garments when it's absolutely naked. The best friend is say, please don't get pneumonia, put some clothes on.
There are instances when the allegation is so wild that you'd have thought the prosecutor would even be surprised and would want to counter-check.
This is cataclysmic. This is an earthquake. I mean, feel the tremors. The house has fallen. So I think let's call it as it is.
Sylvia Chebet, Citizen Business Center.